Hi all, I'm handling topic 11 today of public procurement, and the topic 11 is about administrative review and disposal proceedings. Once a procurement has been completed, there are usually complaints, especially from the tenderers. They will always complain. Maybe something did not go right, something happened and it was not supposed to happen, something did not happen yet it was supposed to happen. So it comes to a time where disputes have to be settled. Of course, in a contract, you cannot fail to get disputes. Disputes will always be there. So when it comes to disputes, then it means someone has been aggrieved. Someone is not okay with the procedure. And most times they are the tenderers who usually start off this process of reviewing. So when we started public procurement, we looked at bodies involved in public procurement. And one of the bodies was called Public Procurement Administrative Review Board, which had only one role or responsibility, if you remember. The role was to review, to hear, and to solve public procurement related disputes. So disputes can occur at any point. We are not saying a dispute will occur only when a process is finished. No. There are those which occur when the entire procurement process has been concluded and a person has been given the tender. They are still understandable. But a dispute can occur even during opening of tenders. A dispute can occur during evaluation of tenders. A dispute can occur even at the stage of an invitation to tender. So any stage of the procurement process, there can be a dispute. So we are not just focusing on maybe after the procurement process has been complete. So if you have a problem with the procurement process or how the procurement was undertaken, what do you do? This topic is so important if you understand that, because one day you will have a problem with the procurement process and you will need a review. So this topic will help you to know how to go about it. So we shall look at what is a review, how do you apply for it, which are these parties to a review, power of the board, what are the remedies you have, what are the offenses and sanctions. So a very interesting topic, especially for the prospective tenderers who may at one point in time have a problem with the procurement process. You appeal. We normally call it you appeal or you ask for a review. So I've said there are two types of review. One is the review when the decision has already been made. At the end of the procurement process, you can ask for a review. Or the second one, at any stage of the procurement process before a contract has been awarded. So that is it. So one thing you need to do, you will first apply for a review. It's not automatic, because not everyone will complain about the process. So you will have to apply, and if you feel like you have suffered loss because of that process, or there is a damage you've suffered because of the process, there was breach of contract, then you have to apply for a review. So you do it within 14 days. The days are usually very strict in public procurement. So after someone has been awarded a contract, it will take you only 2 weeks to apply for a review. If you take more than 14 days, it will not be considered. So after award has been given, 2 weeks you're given to be able to ask for a review in case you feel aggrieved. So there are common areas, and if the contract has not been given, it is at any other stage, you can apply for a review immediately. Let's say it is during the opening, the problem came during the opening of tenders. So during that time of opening, you can ask for a review. So you cannot wait for the entire process to end before you ask for a review. So it will depend with which stage do you feel aggrieved and you need a review. So there are common areas where tenderers will always ask for review. Let me give you some of these areas. The first area is the failure to include an evaluation criteria. In the tendering documents, you have to include an evaluation criteria. If you fail to include an evaluation criteria, that is a common ground for review. Another one is introducing a new criteria in addition to the evaluation criteria later on. So of course there was an evaluation criteria, but during the real evaluation, you find someone introducing a different criteria. That is an area of review. Another one is misunderstanding on the meaning of the lowest bidder. Sometimes people don't understand who the lowest bidder is. Is it the person who has given the lowest price? Is it the person who has given the lowest total cost? You know, there is the difference between the price and the cost. So who is the lowest bidder? So if there is any misunderstanding, you should be able to ask for a review. Not notifying the winning or the non-winning bidders. Remember, in public procurement, you notify the successful tenderer and you also notify those who are not successful. So it means if you do not do that, someone can take that advantage and cancel the entire procurement process through a review. So be very careful as a procuring entity to make sure when you're notifying the winners, you notify the winner, at the same time notify those who did not make it. And because maybe you are using an open tender and many people participated, you can just notify the winner and then notify others why you chose the winner. Because you may not start telling every individual tenderer that you did not win because of this, you did not win because of this. If there are 50 or 100, it will be a lot of work. So you can just inform them that we gave this contract to company A because of these reasons. So you'll have communicated to them why they did not win the tender. So that is it. So when you're applying, those are areas where you should be very keen. In case there is breach of contract in any of those 5 areas, the last one I didn't read, evaluation of offers beyond 30 days. The days in public procurement are very strict. If we say evaluation should be done within 30 days, then you take more than 30, that is an area of review. Someone can take you to court and you can be answerable to it. So evaluation of offers beyond allowed 30 days. So any of those 5 areas could be a very good case or standing ground for someone asking for a review. So once you have, remember you are applying for a review, those are areas you need to apply for. And you are usually supposed to pay a refundable deposit of 15% of the applicant's tender sum. There is an amount of money you pay. Review is not for free. If it were for free, then it means everyone will be asking for review because everyone wants a tender. So it means if you are not so keen, everyone will come back and say, we need this process to be reviewed. And the consequence is it will delay the entire procurement process. Because when a review is in place, then you may not continue with that tender as if it is a normal tender that does not have a review. So a review may stop the entire process of procurement. So to stop people from reviewing every time for very petty issues, there is usually a refundable deposit of 15% of the applicant's tender sum that is usually required. When you're applying, you attach that. So when you're applying also, you have to include the name and address of the applicant, you the tenderer who wants a review, the name and address of the procuring entity, the date of submission of the written application, the reference number. Every procurement has a reference number, and then the signature of the applicant. So whenever you're applying, those areas have to be included. Matters that cannot be reviewed. So you cannot apply the matters like the choice of a procurement method. You cannot review. You cannot go saying, they should have used request for quotation instead of open tendering. No, that's not an area of review. Because the matter concerning the method to use in procurement was determined very early on in the procurement process. In fact, during the planning stage, that is when the method was chosen. So they know why they chose that method. So you cannot go challenging the method of procurement. That one will not be allowed. Termination of a procurement proceeding, that's another reason that is not a strong reason. You cannot be able to review. Whatever method, if the procuring entity decided to terminate a procurement procedure, they have their reason, so you cannot ask for a review. Where the contract is signed by the accounting officer and the successful tenderer incorporating all the agreements. So once everything has been done and it was done in the proper way, you cannot review. You know, sometimes, I've already said this, sometimes people want to review so that they can just waste time. They don't have a strong ground. Where the appeal is futile. It doesn't make any sense. You want to appeal, but you don't have strong reasons why you want a review. And then a decision by the procuring entity to reject all tenders. They could make a decision and say, because we didn't get what we want, we can reject all of them. So you cannot review. You cannot ask for a review, because there are reasons why procuring entities reject all the tenders. There could be maybe the price of the tender is even above the market price. They can reject all of them. So be very keen when you are applying for a review. Is this a matter that is subject to review or a matter that is not subject to review? Because if you reach in front there, it will just be rejected. And then there is usually a statement you have to put in every review that you are applying for. Let me read it. It's long, but let me read it. You will write this statement. I hereby declare that this request is not frivolous and has been made for the purpose of redressing suffering or risk of suffering loss or damage due to the breach of an obligation imposed on a contracting entity by the law on public procurement and asset disposal or the regulation. I understand if the Administrative Review Board determines that this question is frivolous, I could be prosecuted for misrepresentation. So every time you apply for a review, you make sure you put that statement. Because if you end up just applying for the sake of it, or to waste the time of the review board, or to waste the time of the procuring entity, or to make the procurement process to stall, then you could be prosecuted for misrepresentation. So you have already put that statement on your own. So if prosecution comes, you have already agreed to it. And all reviews, they have to have this statement so that you become serious about the review. So you go ahead and look at the review procedure. The review procedure, of course, it will start with what? The secretary of the review board will notify the accounting officer that there is a review that is pending. So they will involve remember the accounting officer, they are the ones who sign the contract, the procurement contract. So the secretary of this board will tell the accounting officer there is someone or there are people who have filed for a review, so that the accounting officer can be able to prepare the response. Remember, they have to respond. If someone comes with a complaint, they have to respond. So they are told so that they can prepare their response. So the secretary also informs the members of the panel, this review board panel, and tells them there is a matter that has been brought before us. We have to sit and review it. So after that, they will do what? The applicant will be given the first priority to be able to state their case, their complaint. So they'll call you in that panel meeting and then they say you had a problem or a review, so state your complaint. You'll come, you state your complaint, they listen to it, everyone else responds, and then you are given the conclusion or what they decide. Parties to the review who are part of that review: 1 is the individual who requested the review. Number 2 is the accounting officer. Remember, an accounting officer is a very big person in public procurement. Number 3, the tenderer, notified as the winner. The person who was notified as the winner has to be part of that review, and then any other person the review board may determine. So there could be more people depending on what the contract was all about. And these people have rights. So the rights and obligations of the parties. So the rights include the right to request for a review, the right to be granted a free and fair hearing, the right to judicial review to the procurement. So those are your rights, especially if you are the person who has brought the review in place. Obligation of the parties. Obligation is what you must do as a party. Remember, the applicant is one of the parties, the accounting officer is one of their parties, the interested party, the expert. So all of them have their obligation. An obligation is what you must fulfill as a party. Like for an applicant, your obligation is to file the complaint and make sure you accompany your complaint with the necessary the necessary law that was violated. Was the Constitution violated, or was the Public Procurement Act violated? So you have to file the complaint and give evidence. An accounting officer has to submit a written memorandum in response. So their work is to respond. So that is the obligation. The interested party, the expert, the review board, they all have their own obligations to be able to fulfill in that particular process. So considerations by the review board. So the review board will look at your complaint. They'll look at all the information you've given. They will look at the information from the accounting officer, the information from the experts. Remember, the expert, even if they know everything, their decision cannot be final. They just come to give their own views. So they will look at information from all those areas, from the registers. So that is the work of the review board. Was this conducted well? So they'll gather information even from the staff members, from other tenderers, to be able to make sure they can sit and make a decision that is informed. So this board has powers. They can nullify everything. They can instruct the head of procurement to do something that they did not do before. They can replace the decision of accounting officer with the decision of the review board. So this is a very powerful board. They can even cancel the entire procurement proceeding if they find it was not in accordance to how it was supposed to be done. So they can terminate the entire procurement proceedings. And they can also order for the aggrieved party to be able to be compensated for losses they suffered. So it is a powerful board, and those are some of the powers they exercise if they find the entity on the wrong. If they find you on the wrong, of course, they will dismiss it. They'll dismiss that particular case. And if your intentions were not so right, they can be able to give consequences to you so that others don't come to be able to do the same. So that is it. That is it. So something else I can still mention. If the review proceedings, you are not satisfied with them, you can appeal. Where do you appeal? To the High Court. So if you find this review decision was not whatever you expected, maybe you still feel they did not give you the right verdict, you go to the High Court. So a person affected, you go to apply for the judicial review by the High Court within 14 days from the date of review. So it will take you 2 weeks. You should have applied to the High Court. And once the High Court listens to it and you're still not satisfied with the High Court, where do you go? You go to the Court of Appeal. So there are 3 stages. You start with the board, the review board, and then you go to the High Court, and then you go to the Court of Appeal. So not all those three areas, they cannot make the same mistake. So it will mean they will have to give you an answer that you want. And if you do not, it's just like that. If you violate the decision of both, all the three, the party to the review who disobeys the decision of the review board or the High Court or the Court of Appeal shall have violated the law, and they can take action on you. So if you go through all these courts or all these three levels and then you still violate what they tell you, then it means your action can be taken against you. So that is it. And then finally down here we have offenses and sanctions. Offenses may be what the Public Procurement Act prohibits. It prohibits things like lying, delayed payments, undue influence, opening sealed tenders. So you can read them through there down here. And penalties, in case you're found doing those things. In case you are found violating the Public Procurement Act in any of those ways, you are obstructing, you are giving misleading information, you are delaying payment, undue influence, you have penalties. There are penalties. If you're a person, you will pay a fine of 4 million shillings. If you're a corporate, 10 million shillings. You can be able to be subject to disciplinary action. You can be debarred. This is one of the areas of debarment. Debarred from doing any business with the public sector. You can be disqualified from entering into any contract, and any contract that you may have already entered into may be considered void. So all that is followed. So this is a very important topic, especially for people who want to do what? To do business or to get tenders from the government. In case things don't go the way you want and you have a complaint to make, then this topic will help you know how do you make the complaint, where do you go, and how can you be assisted in case you have already made the complaint. So that is it for this particular topic. You can read through it slowly and understand every detail about it to be able to understand the review procedure in public procurement.